Hello folks! Okay, what we are going to look at today are the advantages and disadvantages of using judicial precedent. So this is an evaluation question, it's a discuss question. You could get advantages of precedent, disadvantages, or they could put both in there, in which case you'd put fewer advantages and fewer disadvantages. Remember that your points to get into the top level have to be well developed. So it's not just enough to state an advantage, you've really got to explain why it's good, or a disadvantage, why it's bad. Okay, so our first advantage is certainty. So what we like about precedent is you have a clear hierarchy. So the court system is set out. We know the Supreme Court's at the top. Therefore, the rules of stare decisis, stand by what has been decided, is very clear and it's very certain. So this is good because it allows lawyers to advise their clients on the likely outcome. If you've got a precedent there, you know that the court is highly likely to follow that precedent. So this allows people to plan, it allows businesses to plan. It's not all about criminal law. Lots of different types of law exist. Therefore, the fact that you have certainty also means that there is consistency. It also means that justice is achieved because everybody has, the same kind of outcome and lawyers can advise. Also, the fact that you have certainty means that it could save money because the likely outcome is actually going to take less time. Okay. Our second advantage is flexibility. So yes, we're saying there's a clear system of precedent to follow. Everybody knows where they stand. Well, we can kind of flip that and we can say, well, in the law, you do have quite a lot of flexibility. We know the law can be changed. So the Supreme Court have the practice directions 3 and 4 that they can use now. The Court of Appeal has the exceptions in Young. You can also distinguish between the material facts. So law can be changed. So if there is an error in the law, then justice is achieved because the courts have the power to change the law. So judges have an awful lot of power, which can be used to society's advantage, I guess. The other way or the reason that flexibility is good, so if society has changed, society does evolve. When the Offences Against the Person Act was made, nobody knew HIV was going to be a sexually transmitted infection. It didn't exist in 1861. So the judges were allowed to change, or they did change, actual bodily harm to include biological harm. In the case of Chan Fook, they said that actual bodily harm included mental harm. So these are ways that judges have flexibility. They are able to develop the law as society evolves and changes. The next point, which we've kind of touched upon, I guess, in the first bit, I've kind of merged 2 points into one there, is that judicial precedent saves time. Clear structure, you know which court follows which, you know what the law is, a new law doesn't have to be made. So this saves time. Certainty, there's precision, it ensures that the law applies equally to all and it is fair. So you could say that this is also good because it follows the rule of law. And then finally, the idea that judges are legal experts. So we often say that it's undemocratic, Parliament is sovereign, judges shouldn't be making law. Well, I would argue that precedents are clear and they are made by legal experts. Judges have spent a lifetime in the legal profession. So who would you rather making law? Somebody who doesn't know much about law. I'm not insulting all MPs there, but a lot of MPs don't have good legal knowledge. So judges do have good legal knowledge. They are legal experts. They take time to review previous judgments. They do their research. They are not politically, they're not elected. So therefore they are independent. They're independent from the government. They're politically independent. So law, really is being made by legal experts who are independent and who they know what they're doing. Essentially, they will really carefully consider their reasons. And in appeal courts, you have 5 of them, so it's not like you're going to have one judge suddenly deciding something. Remember, it can be a 3-2 decision, which therefore means it can be changed in the future. Probably it will be changed in the future. And also judges can call for Parliament to intervene. Sometimes they're not happy with their role about changing law or making law, and they will actually say, look, this is not our job to make a new law. Parliament, please, can you intervene? So they do actually respect their constitutional position, and they're not going beyond their power. Okay, so the disadvantages of judicial precedent. Well, first of all, it's undemocratic. What does this mean? Well, this means that unelected judges are making law. We know that Parliament is sovereign. Parliament is the law-making body. We vote for the House of Commons, all right, we don't vote for the House of Lords, but it is quite a democratic process. So really, judges should only be applying and interpreting the law. They shouldn't be making the law. So it undermines democracy. It undermines the rule of law. The next point is it takes time. You have to wait for a case to be appealed. So these things don't just happen the next week, the next month, or even the next year. So bad precedents could be law for a long time. So if you remember in Anderton, they said you can't be guilty of committing an impossible crime. So she got away with it. She thought it was a stolen video recorder. It wasn't. Had the case of Shivpuri not happened, then that legal issue would not have arisen for years. It might not even have arisen today, which means that law still would be precedent today. So sometimes cases just are not appealed. Bad precedents may be law for years, or they may get stuck at the Court of Appeal. And that can cause quite a lot of injustice. It also means that people might be being sent to prison in criminal cases. Okay, the next disadvantage are that illogical distinctions are made. So distinguishing may be abused by barristers. I mean, is it clever of them to do so? Possibly. If you are the defendant in a criminal case or a civil case, then great, you want your barrister, your legal counsel, to be able to make distinctions and for judges to agree with those material factual differences. But what I would say is that distinguishing may be abused in order to avoid precedent. So that then leads to uncertainty and can be logical. So we said in the advantages that there was flexibility, but actually you can argue that there is too much flexibility, because if you are distinguishing or saying, you can depart from your previous decision when it appears right to do so in exceptional and rare cases, what do those phrases mean? They're vague. They can be abused to fit the decision that the judges want to make. And then finally, you could argue that precedent is too rigid. So the lower courts have to follow the higher courts. Well, few cases ever reach the Supreme Court. I think they listen to about 7 cases a year. It's really not very many. So it's very rigid, and I know I'm arguing now against the point I just made about illogical distinctions and too much flexibility. Well, I'm now going to say that there's not enough flexibility, that there's a clear structure of precedent. It's very difficult to avoid precedent. Judges take their role very seriously. They don't want to be seen to be making law and going against the sovereignty of Parliament. Therefore, they may stick quite rigidly to the system of judicial precedent. They may just follow bad laws, which means that injustice remains for years to come. And once you get to the Supreme Court, there's nowhere else left to go. So this is problematic. So judge's decision is final. Even in the future, if another case appeals on the same point of law as your case, it doesn't change the decision in your case, because law is not retrospective. So I think precedent overall, I think, is a really good idea, because judges can't wait for Parliament to change the law. Sometimes Parliament will not change the law. So judges are like, hang on a minute, there's an error, there's injustice, we have to change the law. But we've just got to be careful that they're not going beyond their power. Overall, I think I would conclude that precedent is necessary and generally it is not abused.